Good morning, everyone. The court will pick up first number 60, Rowhouses, Inc. versus Smith.
May it please the court, William Parler. I'm joined by Ms. Kelly Grafton for the petitioner Rowhouses. This case lacking any test or record showing that 1622 East Oliver Street ever contained lead-based paint. The plaintiff pursued a Dow causation theory. The plaintiff's mother in this case testified that while they were living at 1622 East Oliver Street, the plaintiff visited 2017 Ashland Avenue on a weekly basis for 2 or 3 hours on each visit. Plaintiff's own source expert in this case, Dr. Simon, testified that he was unable to rule out 2017 Ashland as a source of plaintiff's lead ingestion. Dr. Simon's testimony is put forth at page 157 of the record, deposition pages 54 to 55. And he testified in pertinent part, question, Doctor, have you been furnished with any records at all for 2017 Ashland Avenue? Answer, 2017, no. Originally, I knew nothing about that location until I read the mother's deposition that was apparently the residence of the maternal grandmother for a number of years, and that the plaintiff had visited there during her early childhood. But I know nothing about 2017 Ashland Street other than that the mother made the comment that there was no deteriorated paint. Other than that, I have no information about that address. Question. Do you have an opinion as to whether or not 2017 Ashland Avenue was a source of lead ingested by the plaintiff? Answer, no, because I have no data on it. I couldn't rule it in, and I couldn't rule it out at this point. In addition, on this record, the plaintiff's lead levels during the time that the plaintiff was living at 1622 East Oliver Street declined. The records show that once the plaintiff moved to 1508 North Collington Avenue, the lead levels increased. The one constant was the regular weekly 2 or 3 hour visits to 2017 Ashland Avenue. It was on this record that the trial court entered summary judgment. And unfortunately, it was on this record that the Court of Special Appeals vacated that summary judgment and stated in pertinent part, under Curson and Dow, this evidence could support a reasonable inference by the trier of fact that the Oliver Street property was the only reasonably probable source of lead to which Smith was exposed before she first tested positive for lead on September 25, 1992. Unfortunately, the Court of Special Appeals concludes that Ashland Avenue is not a potential source when plaintiff's own source expert in this case was unable to reach that conclusion. Again, Dr. Simon testified he had reviewed the mother's deposition testimony where she talked about an absence of a deteriorated paint, but was unable to rule out 2017 as a potential source of lead.
Are you saying that the Court of Special Appeals explicitly or expressly found that the Ashland Avenue site was not a potential or could be a potential source?
No, Your Honor, but I do think in that statement that I just read, where they state that the Oliver Street property was the only reasonably probable source, I think they're overlooking the fact that plaintiff's own source expert in this case, Dr. Simon, when asked on this critical issue of circumstantial evidence of lead paint, because we have no direct evidence of lead paint at 1622 East Oliver Street, Dr. Simon is asked, do you have an opinion as to whether or not 2017 Ashland Avenue was a source of lead ingested by the plaintiff? And his answer is, I couldn't rule it in and I couldn't rule it out at this point. So I'm not saying that the Court of Special Appeals expressly rejected his testimony, although the first part of the opinion does state, and I think correctly, that Dr. Simon's opinions on source should be excluded. Nevertheless, on this critical issue of circumstantial evidence of lead in the property. I don't know how the Court of Special Appeals overlooks that the plaintiff's source expert says, with regard to the visitation property, I've looked at everything. We've conducted 3 years of discovery in the case. He looks at everything and says, I cannot rule out 2017 Ashland Avenue as a source of plaintiff's lead ingestion.
What the Court of Special Appeals relied on was that, it must have been Smith's affidavit, that the Smith did not, or that property did not have peeling, chipping, and flaking paint.
That's absolutely correct, Your Honor. And what's significant about that is the testimony I just read of Dr. Simon, plaintiff's source expert. He's acknowledging. He says, in his opinion, I've read the mother's deposition testimony. Mom made the comment that there was no deteriorated paint. The very next question is, do you have an opinion as to whether or not 2017 Ashland was a source of lead ingested by the plaintiff? And plaintiff's own expert says, no, I couldn't rule it in, and I couldn't rule it out at this point.
Well, isn't the point or the test that the plaintiff is required to rule out other reasonably probable sources? And with Judge Green's question, the point is Ashland hadn't become a reasonably probable source. There was no evidence that it was a reasonably probable source. The mother saw no chipping paint. So isn't that the point? The plaintiff has to rule out reasonably probable sources, and we don't know that Ashland is a reasonably probable source.
Well, Your Honor, a couple of things. First of all, I think, unfortunately, Dr. Simon was deposed prior to this Court's opinion in Hamilton versus Curson. But secondly, I think what is significant is he is asked a question, was 2017 Ashland Avenue a source of lead ingested by the plaintiff, period? And he says, I couldn't rule it out at this point. He doesn't qualify it. He doesn't diminish it. He doesn't say because of a lack of deteriorated paint, I think it's unlikely. He simply says, I can't rule it out. So on this issue of probable versus possible, his testimony is, first of all, before Hamilton. But secondly, he doesn't qualify his opinion. He doesn't say, I hesitate. And what is also important to note is, from the time he's deposed until the summary judgment hearing, which was June 27th of 2015, there's no additional deposition testimony. There's no affidavit drawn up from either Dr. Simon or the pediatrician in the case indicating that they've concluded that the property at Ashland is merely a possible source rather than a probable source.
Excuse me. When you're talking about his testimony, he says, I can't rule it out, I can't rule it in.
Yes.
It appears that then you're in equipoise. And in equipoise, if you're determining probity, which is what you're arguing under our case law, it seems to me that that doesn't meet the level of probity because it's in equipoise. I know I'm speaking in tongues, but it just doesn't jive with a sense of weight to be given to what he said. I mean, because we can be in equipoise, and that doesn't even meet the preponderance standard, you know, in our standards. In terms of the weight of evidence and how it should be viewed, how does equipoise meet even any level of probity?
Your Honor, respectfully, with the issue involved here, plaintiff proceeding on a Dow causation theory, where there is no evidence in any of the records or tests that 1622...
No direct evidence.
Correct. No direct evidence. What we're looking at is potential exposures to the plaintiff and circumstantial evidence sufficient to establish the very first burden for the plaintiff in this case, which is to establish that 1622 vis-a-vis circumstantial evidence contains lead-based paint. When you have plaintiff's own expert saying, I cannot rule out 2017 Ashland Avenue.
Well, he says I can't rule it out and I can't rule it in. It's not just,
Correct.
I can't, because that's the equipoise that I'm asking about.
Well, here's the problem, and I understand Your Honor's position with the equipoise, but with that testimony from plaintiff's own expert on this issue of circumstantial evidence of lead in the property, if summary judgment is vacated and this case goes forward for a jury trial, you're going to be asking the jurors to make conclusions about those same issues that plaintiff's own expert, a certified risk assessor, was unable to come to conclusions of.
Let me ask you, if this case had gone to the jury,
Yes.
and the jury had believed the mother that there was no flaking, chipping paint at the Ashland Avenue property, would the jury have been permitted to find that that was not a probable source?
That Ashland was not a probable source? Your Honor, our position
If the
is...
jury believed the mother that there was no, if they had gotten the case and believed the mother, would that have justified their conclusion, a conclusion that Ashland Avenue was not a probable source of lead?
The answer is no, and the reason is the existence of deteriorated paint under the Brooks case goes to whether or not there was a housing code violation and evidence of negligence. However...
Well, doesn't it also go to whether this could have been a source of the heightened lead blood level?
No, because deteriorated paint is irrelevant on the issue of its lead content. Whether or not the paint is deteriorated is completely irrelevant with regard to whether it contains lead-based paint. It's like you'd have an asbestos case where there's a lot of testimony about workers working in a dusty environment without any evidence showing that there was asbestos somewhere in that dust.
If there was lead-based paint in Ashland Avenue, but none of it was flaking, chipping, deteriorated,
Yes.
would Ashland Avenue have been a probable source of the child's increased lead in the blood?
Potentially, which is why Dr. Simon, plaintiff's own expert, couldn't rule it out. And the reason is, as we state in footnote 8 of our brief, part of the definition of a lead-based paint hazard are the existence of lead dust at friction surfaces in a home. So in other words, you can have a lead-based paint hazard where you've got lead dust produced by friction surfaces in windows and doors, completely not dependent, completely independent of any peeling, flaking, or chipping.
That could be speculation, would it not?
Well, again, we're
If it wasn't
back to plaintiff's own expert. If we're talking about quantification of circumstantial evidence, we have a situation, a record in this case, where plaintiff's own expert didn't say, that would be speculation, I can't say this, I don't have it. He said, I can't rule it out.
Well, if he were to rule it out, would he then have to have believed the mother or disbelieved the mother that as to whether there was flaking, chipping?
I don't think there was a credibility determination by Dr. Simon, and I don't think there was any sort of credibility analysis by the trial court. I think what the trial court's looking at is, we've got a case where a defendant has a property and there's no evidence that it's ever contained lead. We've got to look at the body of circumstantial evidence here. And part of what was before the trial court was the fact that in his report and in his deposition at pages 54 and 55, Plaintiff's own source expert, the hired guy to talk about sources of lead, on this issue of circumstantial evidence of lead, says, I've looked at the visitation property, I've looked at Mom's testimony, I've looked at the fact that she says there's no deteriorated paint, and I still cannot rule out 2017 Ashland as a source of plaintiff's lead ingestion. Now, most respectfully, if
What evidence was there that it could have been, other than it was an old house?
Well, you're looking at the same, I think, issues for both houses. 1622 Oliver and 2017 Ashland, both old, both exposures, both elevated lead levels of the plaintiff during the time. The one constant for all 3 or 4 houses, and respondents have a table of this on page 12 of their brief, the one constant is the visitation property. When the plaintiff moves out of our property and moves into 1508 North Collington, the lead levels actually go up. The one constant during all 3 properties is the visitation property.
But I do want to go back to Judge Wilmer's question.
Yes.
If we accept that there is equipoise from the expert's testimony and we have the mother's affidavit, what evidence is there that this Ashland property was a possible source?
Well, Your Honor, I think under Hamilton and under Dow and under West, on this first issue of circumstantial evidence of lead-based paint, first of all, it's part of the plaintiff's burden to connect the dots. It's not the defendant's burden to show, well, it couldn't be our property because there's no evidence of lead-based paint. It's not the defendant's burden under Hamilton, Dow, or West to go out and test. Now, the possibilities of what respondent could have done here are almost infinite with regard to 2017. You could have subpoenaed public records from the City Health Department or the MDE. You could have contacted the present owner, which I think is Johns Hopkins Hospital, to see what records they had about the existence of lead paint or non-lead paint in the property. You could have talked to past owners to get a sense of the repair history of the property. Had the property been through a flood or a fire and been repaired? Had there been paneling put up in the house so that exposure was very unlikely? Those are all infinite possibilities, but that was not the row house or petitioner's burden in this case, because under Hamilton, Dow, and West, the burden of connecting the causation dot in a circumstantial evidence lead case is the plaintiff's.
Well, do you agree that under Dow, the age of the property alone before 1950 is a factor, a piece of the circumstantial evidence that can meet the burden?
No, I don't agree with that. And I think it's certainly a factor that can be considered.
That's my question. Do you agree that it's a factor that can be considered?
I think it is appropriately considered. In this case, we have 2 older properties, 1622 East Oliver in 2017. But here's the problem, and I think this is probably why the Maryland courts in Davis and in other cases have avoided a presumption. Not all properties were painted with lead. Number
I'm
one.
sorry, I didn't catch the last of what you just said. Not all properties.
In Baltimore City were painted with lead-based paint. Actually, lead tended to be used in some of the more expensive properties. It was more expensive, it lasted longer, and so forth. Secondly, without specific historical information, we can't know if a specific property has been rebuilt post-fire or flood, renovated, or raised.
With respect to the first part, does the data show it's something like 95% of the properties were painted with lead-based paint?
I'm sorry.
I've read, I believe, that the data shows that there's a very high percentage of properties that used lead-based paint, something in the 90s.
I'm not sure what the specific percentage is.
All right, let's
And
assume.
also, I'm not sure that that's actually, I don't think it's based on actual door-to-door testing. I think it's more of a projection of the likelihood. But in any event, there are certainly instances where properties have not ever been painted with lead.
Agreed.
There
Here's
certainly
my
are.
question. Here's my question. If that statistic is valid, can that statistic be used to meet a preponderance standard in proving that a particular house had lead paint?
Respectfully, my answer would be no, because you'd have situations where, unfortunately, owners of properties that may have never contained lead-based paint may end up being sued and having judgments entered when there's never been a basis for such a judgment. And I think
I see that. And I think that the Hamilton versus Hurston case basically said that the age of the house is not sufficient. But I'm trying to understand
Yes.
something. We deal with probabilities. We deal with preponderance of the evidence, more likely than not. In that realm, is statistical evidence just ruled out?
I would respectfully submit that in order to avoid having a property owner pay a multi-million-dollar judgment when that property owner may never have owned a property that ever contained lead-based paint, or may have owned a property that at some point from the date of its construction until the date the plaintiff moved in, there had been a flood or a fire or some event requiring reconstruction or rebuilding so that there were no leaded surfaces. I would think we would want to avoid such a presumption so that an owner perhaps of a property that has never contained lead-based paint isn't hit with a big judgment. I think the problem is not all houses were, and I know I've got my life, I can just finish this sentence. Not all houses in Baltimore were painted with lead-based paint. And secondly, without specific historical information about the maintenance and repair and renovation history of the property, we can't know whether that particular house, at the point in time when the plaintiff lived there, contained lead without testing or without circumstantial evidence of that.
All right, Mr.
Thank you.
Parler, we'll let you know how much time you have remaining when you come back to the podium.
Ms. Grafton will be handling it.
Oh, all right, well, we'll let you know then, Ms. Grafton. Mr. Neff.
May it please the court, good morning. What is the standard of proof? Looking at the evidence in the record, it's at summary judgment, view the facts and the reasonable inferences in the light most favorable to the plaintiff, and in this circumstance, the respondent. And the Court of Special Appeals made that very clear in the decision below. The other question, and more resounding, and it appears that that's what the questions that you've been posing to opposing counsel is, the more resounding question is, what is a reasonable probable source? What is the definition of that? Now, certainly this court in the Kierson decision made the distinction between reasonable, probable, and possible. And even when the opinion first came out, the very last page of the opinion, there was a possibility. The word possibility was used. And on motion for reconsideration, this court, in fact, eliminated that from the record and replaced it with probability, because there is that distinction in probability. And I would suggest that in order for us to look at what is the definition of a reasonable probable source, the question would be, could the plaintiff survive summary judgment based on the facts on the record for that particular property that you're looking at? Now, plaintiff's counsel have been criticized over the past years that, they file 100-page complaints, hundreds of counts against everybody on the block and around the corner, when there isn't really evidence of exposure at those locations. This was a focused complaint. And when you don't have testimony of flaking and chipping paint, there is no case. There's no negligence, and there's no evidence of exposure. So in this, I want to be clear because I know defense counsel, petitioner has a chance to stand up again. And that is, the reason why we're here is because in their petition they threw in all the other properties that were mentioned by the petitioner in the petition. And also they were mentioned below. And I direct your attention to page 12 of the respondent's brief, and this is just a blow-up of that page. Because petitioner mentions 1508 North Collington Avenue, 716 Lucerne. There's 2 other addresses on Monroe, and also there's a mention of a McElderry. And he mentions this in his brief, in the petitioner's brief in this case. Mentions Collington on page 5 and on page 19. Mentions McElderry on page 19 and 20. The whole point of me mentioning this now is just simply, and the Court of Special Appeals got it and understood it, and I'll explain to you why, is that what's relevant is the exposure while he was living at Oliver Street. Because there was no evidence of any connection.
Where did these properties come from? I understand they reference them in the brief,
sure.
which I saw, but the reference to the properties originally came from where?
Well, as part of the case, when the plaintiff moved out of East Oliver, went to Collington.
No, I understand that, but were these properties in the complaint?
No, Collington was, but not the other visiting properties. Again, it was much later after Maisha Smith was much older. So it wasn't relevant to the exposure.
So I'm just asking how these came about. Were they developed during depositions?
Yes.
Is that it?
Mm-hmm.
Okay.
In a standard question, both in answers to interrogatories and at deposition, defendants ask mothers, parents, guardians, what other houses did they ever visit? Okay. The question is, are those houses relevant to the exposure? So that's why I just wanted to point that out. But so let's look at, there wasn't any discussion this morning about 418 North Monroe, but it's certainly discussed in the briefs. That was the first property. Is there sufficient evidence to show that we would get past summary judgment? And in that case, I'll point out that the child was only birthed to 6 months of age there. There was no evidence of lead in the house. There were no blood tests in the house, and the child wasn't crawling or walking. That's the testimony in the record, in light most favorable to the respondent. And also simply there was no blood levels. So how could that be? How could we get past summary judgment? I could have never sued that property in part of this case and prevailed. There's just simply not sufficient evidence. So now let's talk about Ashland. So Ashland, again, the testimony is no flaking and chipping paint. Now, Mr. Parler stresses in his argument this morning what Dr. Simon said in this particular case. Well, first off, as he made clear in the record, is he wasn't provided every single possible record about that house. The testimony was there was no flaking and chipping paint at Ashland and didn't spend very much time there. I direct the court's attention to the asbestos cases where I believe you talk about in order for there to be a relationship, there must be proximity and frequency of exposure and
what
duration.
What exactly does the record tell us about the frequency of exposure?
What it says is that there's actually 2 references. One is that Ms. Smith visited her grandmother there once every other week, and there's other references to once every week. Light most favorable to plaintiff, I guess we're going to equipose again, but once a week, but only for 2 hours at a time, 2, maybe 3. So that's 1% of the time is at that particular property. And there's no evidence, there's no evidence, there's no testimony whatsoever that would be significant enough to even have a period of which there could be exposure. I'm sorry.
Judge Atkins had a response to
You're saying that
comment.
2 or 3 hours is not enough for a child to be exposed to lead that turns out to be injurious to the child's health?
It would be not enough to establish that that was the location of exposure. There's no expert testimony in this record. They didn't provide an expert that said, that really would be enough if there was flaking and chipping paint and the child was being exposed at that particular house. That would be enough.
It's your burden to exclude the house.
I understand. But we excluded on the premise that there's no flaking and chipping paint, right?
Is there evidence in the record that when there's no flaking or chipping paint, we can presume that there's no lead paint, or that there's no lead around the...
No. It's not illegal to have lead in a house. So the question is the flaking and chipping is what exposes the underlayers, and therefore that's a necessary ingredient in the facts, if you will, or element in the facts, to establish the exposure.
So there have been no cases in which a plaintiff prevailed without flaking and chipping paint?
Absolutely, you are correct.
On that point, Mr. Nevin, where the evidence as to Ashland Avenue, there is no direct evidence of whether there was lead in the place, lead-based paint.
Right.
The only evidence, as I understood it from the record, is it's an old house.
That's right.
And you could make of that what you would make with Oliver Street. Nothing more.
Well, Oliver has a lot more. But,
Well,
but right.
but in
At that
terms of
point.
whether...
And that's the basis of
Right.
the...
But the new piece with Ashland is the mother's testimony that whatever was there was not chipping, flaking,
Correct.
deteriorating paint. Now, for the expert to opine on whether, in his view, that is a probable source or not, would the expert have to assess the credibility of the mother's testimony if the expert were to think, well, I don't believe her? Then the expert might find, yes, there was. That is a probable source. If the expert were not to believe her, or to believe her, then the expert might say, well, it's not a probable source. But if that's all the expert has, it could explain, could it not, the equipoise. I don't know whether there was, the mother says there was no chipping, flaking paint. If she's right, it goes this way.
Right.
If she's not right, it goes the other way. But I don't know.
One,
And that's a different issue than if the jury would believe that.
Right. Yes, and that's why this case should go to a jury. And
But is it from the expert's perspective, the petitioner is stressing the fact that the expert couldn't rule it in or couldn't rule it out.
right. But the basis of that comment was that, again, he wasn't provided, or there just wasn't additional information about that house.
All he had
to say.
was the mother's testimony and the fact that it was an old house.
And the fact that it was the old house. And that's what's in the record, and it's, it's something that, and the element that it's interesting that the petitioner adds was the definition in the CFR about friction surfaces. If you take that argument, then what you are doing is exposing every owner of a property to potential suit because, of course, every house has windows and doors. That is not reasonable, it's not logical, and it's not a reasonable inference in this particular case. You are correct. The only thing in the record in this case is that Ashland Avenue was an older house, and there was no flaking and chipping paint, and
According to the mother.
right, and not there very often. Well, according to the mother, again, the case law for centuries, is it's like most favorable to the plaintiff at this stage, and it is. And in Ross,
as to summary judgment,
Right.
but my question deals with the opinion of the expert.
which Ross says one you don't even need to have, right? Didn't they? They had specifically said you don't have to have the expert, the medical expert, in that particular case, say that the house was the source. It is a matter for the jury to decide.
Well, don't you need the expert to say that unless it's chipping and peeling, there could be no exposure to lead paint?
You do have discussion about that, sure, but it's not an opinion.
Don't you need to have the expert say that? Because all you have to rule out that house is the mother's testimony that it was not chipping or peeling.
Correct. And we do that, again, through medical expert, just general testimony about general issues with childhood lead poisoning.
And can you point me to that testimony?
In this case,
Well, I thought that's what we were discussing.
it was it was really Dr. I believe it was Blackwell White in this case. That wasn't really an issue, and I don't believe that was. I mean, it may be in here, the medical expert's report and testimony.
I'm just wondering about, it used to be more common, I think, than it is now about getting expert opinions based on hypotheticals.
Yes.
And I suppose it could have been asked, if you believe the mother that there was no flaking or chipping paint, would you have an opinion as to whether that is a probable source?
Right.
But that wasn't asked.
That was not asked.
Okay.
But then, again, from our point of view, our focus wasn't on Ashland, and we had the testimony that there was no flaking and chipping paint. It wasn't asked by the other side either, so that's the quandary there.
I just out of curiosity, Mr. Nevin, do I recall that one of the buildings has been at issue here was raised?
The Oliver Street,
Oliver.
yes. Which goes to, again, the petitioner's argument that, well, Dr. Simon didn't even go to the property and conduct an investigation and do all that other stuff. It was an impossibility. This is a historical review based on the information that was available. The law is in place to protect landlords. If you keep your properties free of flaking and chipping paint, you don't get sued. Okay? The petitioner cites the CFR and COMAR, okay? But they want you to ignore the other aspects of that says there is a presumption in the state of Maryland that houses built before 1950 contain lead. It's already there.
Which applies to both houses.
Which applies to both houses, and I know it cuts both ways. But you see, I cannot prove a case, and it would not get to summary judgment, unless I had other facts. And in this case, I have a lot of facts. I have this house, Oliver, was built in 1916. The prior home was testified was in good condition. There was no evidence of blood lead levels at any time, and the plaintiff, the respondent, did not crawl or walk.
Yeah, that's not a hard issue.
Okay. The first blood lead level was in September of 92. And in fact, the mother testified when she first moved in, she didn't see flaking and chipping paint. It wasn't until later. If the assumption that's being raised is that she's not telling the truth, although it's not an issue to be addressed at summary judgment, why would she have even said that? Okay, so we don't have Consumer Protection Act in this case, and we submitted it at summary judgment on that count. But she said it wasn't until after, and it's approximately 6 months after they move into Oliver is the first blood lead test recorded. There's testimony about hand-to-mouth activity of this child in the house, both on the floor and on the windowsills. She spent the majority of her time at Oliver. There's also in the record, there's no babysitters, no daycares, no parks or playgrounds. There's no other environmental sources. It's in the record through the affidavit and testimony. No painted toys, no cosmetics, no indication she played in the soil or anything like that. So we were going through and eliminating the other sources as we were investigating this case. It's 1% of the time is what she spent at Ashland. We didn't deny that. It's every other week, maybe 2 to 3 hours. And Ashland was described in good condition. The next door, all right, the house next door to Oliver, had been tested previously by the Baltimore City Health Department and found to have lead. That was provided to the court. It was a late supplement to the record, but I need to draw the court's attention to the fact that this hearing in Maisha Smith at the trial court level was just 5 to 7 days or 8 days after the Kearson ruling was published. And so we went frantically and we got documents. We got not only next door, which was built the same year by the same builder, but also other properties within that block area also contained lead that had been previously tested. We put that all into the record. And also, as we mentioned in our brief, is that the petitioner in this case had registered his property in accordance with the Lead Act that was passed in 1994 and implemented in 96 as an affected property. What is an affected property? The state of Maryland says any house built before 1950. And then later on, they've changed that to 1978. It's based on the statistics that are out there. The EPA, the MDE, and now the state lawmakers have adopted that as part of the Risk Reduction Act. What's the purpose? Is to prevent exposure to children, because everyone knows, and this is where science meets the law. Everyone in science is trained and taught and knows that houses built before 1950, more likely than not, and actually almost beyond a reasonable doubt, contain lead. It's 95%. It's in the documents. The EPA has published that. And so, so then the question is, wait a minute, 1978, does that mean a house in 1968 could have had lead? Not in Baltimore City. Why? Because the Baltimore City Housing Code was passed in 1966, and it banned the use of lead. I have never had a case where it found a house built after 1966 in Baltimore City had lead. Okay? So that's just what the science is. That's what the reality is, and that's why I'm asking this court in this case to really look at the issue of that presumption. But it is not the only piece of evidence that we could go forward to win a case. We still have to show the duration, the exposure, the opportunity to be around the flaking and chipping paint and leaded dust. It all goes to the circumstantial evidence and a reasonable inference in this case, and that's what the Court of Special Appeals said. Looking at the totality of the evidence, it was reasonable that this house, the Oliver Street house, was a reasonable probable source of the lead. We're not burdened as the only source. There can be more than one source, as is consistent with the law in the state. So to say, so what if Ashland? Let's assume their argument. That doesn't preclude going forward. But under Kirsten, I understand, or in the Dow theory, if we're saying this is the house, East Oliver, we do have to try to rule out all the other properties.
And on that note, can you go through with us how the absence of chipping and flaking paint would equal or establish an absence of lead exposure at Ashland, and what evidence you have in the record of that?
Sure. Let me first direct you to the law, the lead reduction law, and it says if you're in an affected property, you either prove that there's no lead by testing it, or make sure that the house is lead safe. What does that mean? It's usually done just by visual inspection. They have to get a certificate, and that means there's no flaking and chipping paint. So the law recognizes that if there's no flaking or chipping paint, the house is lead safe. Okay? So, I'm sorry, back to the exact question.
Can you just go through with us what, in your opinion, in the record would demonstrate that the absence of flaking and chipping paint equals an absence of lead exposure at Ashland?
Well, the record is just simply, the testimony. I mean, it's the science of childhood lead exposure. It's what the CDC, the American Academy of Pediatrics, and all the publications, Nelson's Handbook on Pediatrics, is that the exposures related to the primary source of exposure these days is related to deteriorated paint in old housing. That is lead-based.
You used the fudge word primary.
Yes. Okay, looking at the entire environment. There are other sources of lead in the environment. I've never denied that.
In a house?
The house is the primary for young children, they found. An old house with deteriorated paint is the primary source of exposure. That's as to the medical terminology.
But following up on Judge Watts' question, might there be some secondary
Are you asking about possibilities? Anything's possible.
I'm
There's
asking
no-
about secondary.
Well, secondary is, again, there's nothing in the record that would address a secondary exposure. In fact,
At the Ashland property.
we eliminated that.
That was built before,
Before 1950.
okay.
Are you presupposing? Are you hypothetical? It's not in the record. I mean, we got to deal with what's in the record. Anything is possible. I'll never disagree with you on that.
Well,
But there's no evidence that she was, eating a large amount of soil, or that we had a water problem similar to Flint, Michigan right now. We've never had an issue with water or lead in water to the point of it being a problem in general housing in Baltimore City.
But I thought you answered before that you weren't sure if your expert said that without chipping and or flaking paint, peeling paint, he or she couldn't say one way or the other whether the house was included or excluded.
I didn't say that, but generally, if there's no flaking and chipping paint, there is what happens if there's no flaking and chipping paint. Generally, they say no, that wasn't a source of exposure, and then the other side comes in. Well, what about this? What about that? What about that? But there's no evidence of those other additional factors.
And I did understand you to say earlier that Dr. Blackwell White may or may not have testified about
Yeah.
the concept of chipping and flaking paint and lead exposure. So what are you telling us about Dr. Blackwell White's testimony on this issue?
Let me check to see. I can't even tell you at this very moment whether I'm sorry, let me correct you, because it's Dr. Vera Brown, who's our expert pediatrician.
Well, actually, you said it was Dr.
I know. I said I wasn't sure. I almost certainly. So anyhow, it's Dr.
okay to
Vera
be wrong.
Brown, who is, I see that here. And let's go 365. Starting at 366 is Dr. Brown's report. And again, this isn't something that was considered, in the lower court, or it was really argued. The issue was, as to whether there were other reasonable, probable causes of the exposure. On page 368, I'm reading this for the first time. In summary, Maisha Smith, first time today, was exposed to flaking and peeling paint at 1622 East Oliver Street and 1508 North Collington. That's the later property. That's not relevant to the motion that was below. This exposure took place during the first 2 years of life when her developing brain would have been susceptible to the effects of lead. That's it as far as to the exposure statement. Okay. So that's the extent.
Right. I'm looking at the report, and you're more familiar with the record than we are. Do you know if Dr. Brown knew or had it supplied to her as a fact that the child resided at or visited Ashland?
I believe if you look at the list of documents that she had reviewed, she routinely puts in the front. She had the answers to interrogatories at the time. And this would be the time of a report. I can't tell you offhand. Again, it wasn't an issue, I believe, at the summary judgment, whether we attached or whether she'd been deposed at that point in time. But I know the answers to interrogatories are also in the record.
Okay, thank you.
Okay.
Just by way of curiosity, I seem to remember that there were some allegations, not in this case, that children could ingest lead paint from sucking on counters or whatever, you know. I mean, weren't there allegations of that in the past rather than just chipping and painting?
Well, the environmental investigators, the lead risk
Right.
assessors and things like that, look for, so there's this condition called, chewable surfaces,
Yes.
such as windowsills
That's
and things like that.
that's what I recall.
But you would need, obviously, you need evidence in the record to say that that was occurring. There isn't in this case that she was chewing windowsills at Ashland Avenue.
As a point of clarification, you directed us to Dr. Brown's report, and there's multiple references to Collington. That's off the table, isn't it, for purposes of what we're
Yes, because that was
considering
after
today?
they moved out. That was after they moved out. So the court, I guess, counsel for the petitioner may say that there's a robust argument that homes, should not be old homes, do not have lead paint. But he can't point to one document that really creates that argument. There is a one document out there. It was a HUD study in April 2001 that was published. They went around looking at houses and living situations that may contain lead. But in that study, they also, investigated mobile homes and trailers. That's not a situation applicable to Baltimore. But sure, the percentages in there was less lead, not the 95%. But the EPA, the MDE, and the state of Maryland had all adopted that position. The presumption is in the law, and there are protections in the law. There are protections for landlords who maintain their homes free of flaking and chipping paint. There's also ways, if you have a property that is built before 1950, you can go and test it to determine that it doesn't have lead. Or you can gut rehabilitate it, or take out all the painted surfaces and replace them.
I noticed that you had less than a minute, so let me just return to some questioning from earlier. And it was Judge Battaglia questioning opposing counsel about Ashland, and the expert could not rule it out, Ashland could not rule out or in.
Yes.
In short, what is your position with regard to the Ashland property? Does it take Ashland off the table? Does it just reduce? Where are you?
There isn't sufficient evidence to make Ashland a reasonable, probable source. Okay? I asked that very question of the trial court right at the end of the hearing. And I believe it's on page 511 to 512. Look at that. I said, Your Honor, are you finding that Ashland Avenue is a reasonable, probable source? Because that's the only way that summary judgment really could have been granted. And she said, I have. But where is the evidence? It would never get us past summary judgment if we sued Ashland Avenue. The child wasn't there enough. There was no flaking and chipping paint. And that's how we feel about it. That the only house, and we've established the burden under doubt. The only house was the Oliver. Thank you very
Mr.
much.
Nevin. Ms. Grafton, and you have 7 minutes.
Thank you, Your Honors. Good morning. Kelly Grafton in response. I have a couple of things that I would like to discuss that were brought up by Mr. Nevin, so I'm going to bounce around a little bit if you don't mind. The first is this question of what makes a reasonably probable source. Mr. Nevin started out by saying, what is the definition of reasonably probable source? And you know what? I have the same question. What is that definition? Respondent concedes that she must rule out reasonably probable sources, and she also concedes that Ashland Avenue is at least a possible source of exposure. Okay, so what gets it over the level? What makes it from possible to a probable source of exposure? Well, let's look at the evidence that we have as to Oliver and Ashton Avenue, because I submit that if Ashton Avenue is not a reasonably probable source of exposure, neither is Oliver. And here's why. Plaintiff had elevated blood lead levels while visiting both properties. She was at a crawling age while at both properties.
Well, she resided at one of them.
Sure, she did, but she regularly visited the other. At the same time she was going to both properties, she was exhibiting hand-to-mouth activity. Both are old homes in Baltimore. The only difference between Ashland Avenue and Oliver Street is Mom's testimony about deteriorated paint. Mr. Nevin went so far as to say, without testimony of deteriorated paint, we have no case. And I submit, having been doing lead paint work for a bit now, there have been plenty of cases where the plaintiffs have attempted to continue their case without evidence of chipping or peeling paint at a property. And that's because chipping paint doesn't necessarily mean lead-based paint. And in the reverse, intact paint doesn't necessarily mean that there wasn't a lead-based paint hazard. And of course, we're talking about...
That last statement.
Mm-hmm.
What is in the record of this case to establish that?
Well, the record of this case, in our motion for summary judgment, we cite to the definition of lead-based paint hazard, which includes the creation of lead dust by friction surfaces, windows, doors, that sort of thing. At summary judgment stage, we did not have our expert testimony in there about the ingestion of lead dust, but the CDC considers lead dust to be a primary source of exposure, and those cases, those studies were cited by even plaintiffs' own experts in this case. The record before the court at this time was that plaintiff was visiting Ashland Avenue every week. I know there's some question now about whether it was weekly or every other week, but the record submitted before the court was that it was weekly. But the point is, there's no expert to explain to us what the significance is of 1 hour versus 2 hours, 1 day a week versus 3 days a week. I don't know. I don't know what is significant and what is not. I know that I've read many studies, including the studies from Dr. Lamphere and Dr. Canfield that are cited by each one of plaintiffs' experts that say that there is no insignificant amount of lead exposure. That even at very, very small levels of lead exposure, you can have tremendous injuries. Plaintiffs' attorneys are talking about that all the time. So
but you don't have that in evidence here.
Those studies were cited by plaintiffs' experts in this case and were before the court, before the court at summary judgment. So those issues are part of the record here, that even insignificant exposures to lead can cause elevated blood levels. So who am I, or who is a lay jury, more specifically, to say that, 2-3 hours a week or 2-3 hours every other week, that's not enough? Mr. Nevin said it several times when he was standing up there, that was insignificant and it's not enough. Well, he's not an expert. And the expert that they did have in this case, Dr. Simon, he had that evidence. He had that testimony from Mom that said it was only once a week or maybe once every other week, whichever way you want to go on that. And he said he couldn't rule it out based on that information. He had read the deposition testimony. He had all those facts, and he couldn't rule it out. So
is there any evidence from Mom's deposition or anywhere else as to whether the child, when visiting grandmother at Ashland Avenue, was supervised or what the child did? Is there any evidence of that?
No, there's no discussion in the deposition testimony from Mom as to what they did on those weekly visits to Ashland Avenue. But we do know that at that age, she was crawling. So, we could all picture babies crawling on the floor. They're going to get whatever's on the floor on their hands. And the testimony was that she had hand-to-mouth activity on a daily basis. So certainly that would include the days she was at one property versus days she's at another. I don't know any baby that can stop sucking on their fingers for certain days. So if you look at, may I borrow your chart? If we look at Mr. Nevin's chart here, the one thing that is consistent in respondent's life is Ashland Avenue. Every single one of her elevated blood levels occurred while she was living at Ashland Avenue.
Not living.
I'm sorry?
Visiting.
While she was visiting Ashland Avenue. Does that mean she was necessarily absolutely exposed to lead at Ashland Avenue? I don't know. The point is, that alone should be enough to have raised the question for their expert. Their expert needed to consider Ashland Avenue. Somebody needed to look at that and say, gee, she was there every time she had an elevated blood level for at least some point. She was visiting weekly, and then she possibly was visiting every other week, and that corresponds maybe with her blood levels declining. Interesting, right? But we don't have an expert to explain that to us. There's nothing in the record to explain the significance or lack thereof of that constant exposure to this unknown property. And it's not defendant's burden to investigate Ashland Avenue to make it not be or be a reasonably probable source.
Was the
On that-
mother ever asked about whether she observed dust in either house?
I'm sorry, was the
Oliver
mother
Street or
asked?
Ashland Avenue?
The mother was asked one question about Ashland Avenue towards the end of her deposition, which was whether she recalls seeing chipping, peeling, or flaking paint there, and she said no. There wasn't inquiry about dust or the general condition of the property, so we don't have any more than that on
So
this
the answer
record.
is no, there was no testimony either way.
Correct.
Ms. Grafton?
Yes.
Oh, never mind.
All right, I
That's it.
see that I am out of time. Thank you
Yes,
very much.
thank you, counsel.